followed through our first session, we introduced the mistakes in a general angle of it. But we never discussed how you will be in a position to know the exact offense that you're supposed to charge a person, and why some offenses will confuse you if you have not yet looked at that exact provision and practiced on how to draft the charge with a pen and a paper. So today's session, it is deliberate, where I'll be beginning from where we left on page 10. So don't worry by thinking that you missed a lot, you never missed a lot. This is where we are now starting to do the real session. So one thing that I like to begin with is in various terms that you need to understand before even doing anything. So you need to understand the definition of an attempt. So an attempt is where an accused person has tried to commit an offense but has not completed it. It was featured in 2022 paper, Criminal Litigation, where a person was caught in a supermarket while attempting to steal the items. So that is identifier number one. Identifier number two is conspiracy. Conspiracy was tested in the April 2026 paper in the mandatory question paper, where they invoked a child conspiring with an adult. You have also captured the mistakes that you are likely to do when charging the two individuals. And three, okay, let me give you the definition of conspiracy as per the screen. Conspiracy is where the accused has agreed with another person to commit an offense, but the offense may not yet have been committed. Okay, that is conspiracy. Three is aiding and abetting. This is where the accused assists, encourages, facilitated, cancelled, or procured another person to commit the offense. Okay? So first, if you master these elements, you will now understand the basis of where I'm coming from. Then, the fourth element that I want you to capture is on handling stolen goods. This is where the accused person has received, has retained, has disposed of, or assisted in dealing with stolen property after it had been stolen, but may not have participated in the actual stealing. Okay? So we find students charging a person who's supposed to be charged on handling stolen property, and the same person is being charged with aiding or abetting, and he never participated in the actual stealing. We will see that mistake and why you should listen to this session attentively to avoid falling into the trap. So the charge must match what the evidence can prove. If the accused is charged with the wrong offense, the charge will fail because the prosecution will not prove the essential ingredients. So let us start with the first mistake that you'll do. The mistake that you'll do is to charge theft, where the facts only show an attempt to steal. So an illustration of this is where you have been told a person has entered into a supermarket. This person has hidden items under his jacket, but he is stopped by the security before leaving the premises, and the items are recovered before he exits. Okay? So you are going on to charge a theft, but the factual matrix is showing you an attempt to steal, because we've been told that the items have been recovered before he exits. He exits the premises. It is a wrong charge to charge a person contrary to section 268 as read with section 275 of the Penal Code. I know you are wondering why I'm going to read out the exact provisions, and yet it is a direct interpretation that section 268 is on theft or stealing. This is invoking what we call visual memory, because once you are in a position to see the section, you avoid a situation where we call a cramming. So in your mind, you will be referring to this webinar and remembering the scrolling and even the reading out of the exact provision, because CLE will test on the common offenses as compared to the detailed offenses. So if you read section 268, let me scroll downwards quickly because of time. If you read section 268, this is it. I want to show you how people lose marks. So let us first deal with the definition of stealing. A person who fraudulently and without claim of right takes anything capable of being stolen or fraudulently converts to the use of any person other than the general or special owner thereof any property is said to steal that thing or property. A person who takes anything capable of being stolen or who converts any property is deemed to do so fraudulently if he does so with any of the following intents. That is to say, an intent permanently to deprive the general or special owner of the thing of it. B. An intent to use the thing as a pledge of security. C. An intent to part with it on a condition as to its return which the person taking or converting it may be unable to perform, and an intent to deal with it in such a manner that it cannot be returned in the condition in which it was at the time of the taking or conversion. In the case of money, an intent to use it at the will of the person who takes or converts it, although he may intend afterwards to repay the amount to the owner. And a special owner includes any person who has any charge or lien upon the thing in question or in right arising from or dependent upon holding possession of the thing in question. Now, why am I reading it together with section 275? This is the general punishment for theft, where we are told that any person who steals anything capable of being stolen is guilty of the felony termed theft and is liable unless, owing to the circumstances of the theft or the nature of the thing stolen, some other punishment is provided to imprisonment for 3 years. So these are general punishment for theft. Remember, the moment you are also reading out these penal provisions, it will also help you in drafting penal provisions in the LWD unit, because many students usually don't know how to create an offense and the general punishments for certain offenses. So it will come out automatically because you are going to make reference to various offenses. So now back to the question, why was it a wrong charge? It was a wrong charge because for stealing, the prosecution must prove that the accused fraudulently and without claim of right took something capable of being stolen with the necessary intention to permanently deprive the owner. So look at those ingredients. They were captured directly from section 268. Look here, fraudulently, without claim of right, takes anything capable of being stolen. Okay? And you are having an intention to permanently deprive the owner. If the evidence shows that the accused was stopped before completing the act of taking, the safer charge may be attempted stealing, depending on the facts. So the better charge in this situation, where we were discussing in the supermarket thief, it was an attempted stealing, contrary to section 389. Let us go to 389. You see whether the factual matrix supports 389. Good. So if you read section 389, it is telling you something. It is attempts to commit offenses. Any person who attempts to commit a felony or a misdemeanor is guilty of an offense and is liable if no other punishment is provided, to one half of such punishment as may be provided for the offence attempted, but so that if that offence is one punishable by death or life imprisonment, he shall not be liable to imprisonment for a term exceeding 7 years. Okay? Now, the better charge that the examiner was expecting is you mention attempted stealing contrary to section 389 of the Penal Code as read with section 268 and 275 of the Penal Code. And the drafting point is that you do not charge the completed offence simply because the accused intended to commit it. If the act was interrupted before completion, you consider an attempt to that offence. Okay? So always put that into consideration. If the act is not fully completed, then you remember section 389 of the Penal Code. Now, the other mistake that you'll do is to charge robbery with violence where facts only show attempted robbery. And a good illustration is where the examiner tells you that 3 men armed with knives confront a motorist and demand money. But before they take anything, police arrive and arrest them. Remember what I've said? You are making a mistake by charging robbery with violence where the facts only show attempted robbery. So the wrong charge, you will say robbery with violence contrary to section 296(2) of the Penal Code. If you go to section 296(2), I'm saying this is deliberate. I know it provides for the offense of robbery with violence, but this is for visual. 296(2). So 296(2) tells us that the 296 generally it is punishment of robbery, and any person who commits the felony of robbery is liable to imprisonment for 14 years. If the offender is armed with any dangerous or offensive weapon or instrument, or is in company with one or more other person or persons, or if at immediately before or immediately after the time of the robbery, he wounds, beats, strikes, or uses any other personal violence to any person, he shall be sentenced to death. Okay? That's why you have used robbery with violence. You meet one of the conditions outlined before because the act is using or. Now, the problem is that robbery involves stealing, accompanied by or followed by violence or threat of violence. If nothing was actually stolen, the completed robbery may not be proved. So the better charge in this situation is to charge the accused person on attempted robbery with violence contrary to section 297(2) of the Penal Code, outlined before your screens. So section 297 of the Penal Code tells us about attempted robbery. And it tells us that any person with any intent, any person with intent to steal anything, and at or immediately before or immediately after the time of the assault, uses or threatens to use actual violence to any person or property in order to obtain the thing intended to be stolen, or to prevent or overcome resistance to its being stolen, is guilty of a felony and is liable to imprisonment for 7 years. So let me repeat that part. Any person who assaults any person with intent to steal anything, and at or immediately before or immediately after the time of the assault, uses or threatens to use actual violence to any person or property in order to obtain the thing intended to be stolen, or to prevent or overcome resistance to its being stolen, is guilty of an offense known as felony and is liable to imprisonment for 7 years. 2. If the offender is armed with any dangerous or offensive weapon or instrument, or is in company with one or more other person or persons, or if at all immediately before or immediately after the time of assault, he wounds, beats, strikes, or uses any other personal violence to any person, he shall be sentenced to death. So, take note, section 297(1) is on attempted robbery without violence, because you have threatened. When you read section 297(2) of the Penal Code, it is on attempted robbery with violence. That's why we said the correct charge in this situation, because he was armed with dangerous and offensive weapons, it was attempted robbery with violence, contrary to section 297(2) of the Penal Code. And the drafting point that I want you to capture is that if violence or threats occurred but no property was taken, attempted robbery may be more appropriate than robbery. No property was taken, so don't be quick to charge a person on punishment for robbery and yet that thing or that property was never taken. The other mistake that you will do is to charge a person with obtaining by false pretenses where no property or money was actually obtained. This is another mistake that you will do. An illustration of this is stated where an accused person falsely tells a complainant that he can sell him land. The complainant discovers the lie before paying any money. And you, as a student who never read or attended these webinars, you directly state that there is an offense of obtaining money by false pretense contrary to section 313 of the Penal Code. Section 313 of the Penal Code is on obtaining by false pretenses, where any person who by any false pretense and with the intent to defraud obtains from any other person anything capable of being stolen, or induces any other person to deliver to any person anything capable of being stolen, is guilty of a misdemeanor and is liable to imprisonment for 3 years. Now, why is that provision wrong? The offense of obtaining by false pretenses require proof that the accused actually obtained something by means of false pretense. Listen to the language used by the Act. Any person who by any false pretense and with intent to defraud, obtains, okay? Obtains. You have already obtained. So, if there is nothing obtained, automatically you cannot enforce that provision. If no money, goods, or benefit was obtained, the completed offense is not proved. So the better charge that the examiner will be looking for is attempting to obtain money by false pretense, contrary to section 389, as read with section 313 of the Penal Code. Now take a look at how section 389 is proving to be of paramount importance, and also take the approach why it is important to project the Penal Code, because we are now connecting various sections. Section 268, 267, 313, okay, 389. Those are the those are so far the provisions that we have come across. Section 296(2) and even section 297(2) on attempted robbery with violence. So I want these sections to come out clearly without even cramming, so that if you are to enter into the exam room with your Penal Code, automatically you know where to open and confirm something. Now, the other offense, the drafting point that I want you to first take away in the attempting to obtain money by false pretense is that where the accused made false representations, but the complainant did not part with any money or property, you consider an attempt. That is well settled. Section 389. Now, the other mistake that you will do is to charge stealing where the accused only received stolen property later. This one even appeared in our project work. You are told by the examiner that a phone has been stolen from a complainant in Nairobi CBD, and 2 days later, the accused is found selling the phone. There is no evidence that he participated in the original theft. So it is a wrong charge to charge this individual with stealing contrary to section 268 as read with section 275 of the Penal Code. And why it may be wrong is that to prove stealing, the prosecution must connect the accused to the actual taking of the property, because mere possession of recently stolen property may sometimes support an inference of theft, but where the evidence only shows later possession, receipt or sale, the more appropriate charge may be handling stolen goods. So now the examiner tells you, because you know so much and you should not charge stealing contrary to section 268, now tell us where handling stolen property is provided in the Penal Code. And remember, you cannot fail to know the provision, because failure for you to capture the provision, then your charge sheet will be defective. Handling stolen goods. Section 322. A person handles stolen goods. I hope I'm recording the session. Najua nikisema hivyo mnashtuka. Yes, I'm recording. So, let me Good. So, handling stolen goods. Niweke laptop kwa moto. So, handling stolen goods, we are told by section 322 that a person handles stolen goods if otherwise than in the course of the stealing, knowing or having reason to believe them to be stolen goods, he dishonestly receives or retains the goods, or dishonestly undertakes or assists in their retention, removal, disposal, or realization by or for the benefit of another person, or if he arranges to do so. 2. A person who handles stolen goods is guilty of a felony and is liable to imprisonment with hard labor for a term not exceeding 14 years. And for purposes of this section, goods shall be deemed to be stolen goods if they have been obtained in any way, whatever under circumstance which amount to felony or misdemeanor, and still means so to obtain. And no goods shall be regarded as having continued to be stolen goods after they have been restored to the person from whom they were stolen, or to other lawful possession or custody, or after that person and any other person claiming through him have otherwise ceased as regards those goods to have any right to restitution in respect of the stealing. So where a person is charged with an offense under this section, it shall not be necessary to allege or prove that the person charged knew or ought to have known of the particular offense by reason of which any goods are deemed to be stolen goods. And B, at any stage of the proceedings, if evidence has been given of the person charged having or arranging to have in his possession the goods the subject of the charge, or arranging to have, or his undertaking or assisting in, or arranging to undertake or assist in their retention, removal. Okay, I'm having a phone call here. Kidogo tu. Hello? Yes. Oh. Okay, sawa.
Brian, Brian, apologies, guys. Victor is addressing an emergency. He'll be coming back soon.
So thank you so much for your indulgence. And we were on the part of analyzing so that we understand clearly the intention of the legislature when they were proposing this charge. So we are told that at any stage of the proceedings, if evidence has been given of the person charged having or arranging to have in his possession the goods, the subject of the charge, or of his undertaking or assisting in, or arranging to undertake or assist in their detention, removal, disposal, or realization, the following evidence shall, notwithstanding the provisions of any other written law, be admissible for the purpose of proving that he knew or had reason to believe that the goods were stolen goods. 1. Evidence that he has had in his possession or has undertaken or assisted in the retention, removal, disposal, or realization of stolen goods from any offense taking place not earlier than 12 months before the offense charged, provided that 7 days notice in writing has been given to him of the intention to prove the conviction, evidence that he has within the 5 years preceding the date of the offense charged been convicted of stealing or of receiving or handled stolen goods. So this is an exception to the rule of the thumb, where it is arising during the stage of the proceedings that he even arranged on how those goods will be possessed. Now, we were saying that the better charge in this situation will be handling stolen goods because he is not in any way participating in stealing the items. And the possible particulars, now if you are keen, you will notice that I have now started going to a full detail on how the particulars should appear, because the marking point is on have you understood the correct charge, 1 mark, and have you narrated the possible particulars in a way that we will understand. So on the 15th day of June 2026, where at Nairobi CBD within Nairobi County, otherwise than in the cause of stealing, dishonestly retained or assisted in the disposal of one Samsung mobile phone, what is its value? Valued at Kenyan shillings 45,000, knowing or having reason to believe it to be stolen property. Okay? These are the exact particulars or ingredients of the offense of handling stolen properties. Because of this part, you have handled a stolen good, and otherwise than in the cause of the stealing, you never participated in the stealing, knowing or have reason to believe them to be stolen goods. So it is irrelevant whether you knew or have reason to believe it to be stolen property. It is immaterial. Okay? Then you will be charged for handling stolen goods contrary to section 322 of the Penal Code. So the drafting point that I want you to extract from this kind of an exercise is that handling is appropriate where the accused role begins after the theft. The other mistake that you will do is where you will be charging handling where evidence shows participation in the original theft. So that is the vice versa of it. And this time you are told that a shop attendant helps another person remove goods from the employer's store at night, and the goods are later found in the attendant's house. So the wrong charge will be to charge that a shop attendant on handling stolen goods contrary to section 322 of the Penal Code. So you have tried to navigate around the statute by saying that you handle these items after they have been stolen. So this may be wrong because handling usually applies where the accused deals with stolen property otherwise than in the cause of stealing. Okay? If the accused participated in the actual taking, the proper charge may be stealing or stealing by servant, depending on the facts. So the exception will apply otherwise than in the cause of stealing. You never knew where these items were stolen from. But if you knew where they were stolen from, you even participated by opening up the door, then hiding behind another person so that you can now be charged on handling stolen property. That will not be the case. You don't fall under this exception. You are in the cause of stealing. So the better charge will be stealing contrary to section 268 as read with section 275 of the Penal Code. And I've said I will not reveal section 268 and 275 because we already started with those provisions. Now I expect this provision to have stuck at the back of your fingertips. Or if the accused is an employee and the property belongs to the employer, now you invoke stealing by servant contrary to section 281 of the Penal Code. So stealing by servant, let us look at its ingredients. We see, so stealing by clerks and servants, if the offender is a clerk or servant and the thing stolen is the property of his employer or came into the possession of the offender on account of his employer, he is liable to imprisonment for 7 years. So that is stealing by clerks and servants. Now, what is the drafting point that I want you to have is that do not use handling where the accused is alleged to be one of the actual thieves. Mistake number 6, I told you this document carry a lot of mistakes that you never imagined it could be pointed out. So charging the main offender where the accused merely assisted. So a good illustration for you to understand is where a person keeps watch outside a shop while another person breaks in and steals the goods. In April 2026 paper, the small boy, a minor, was watching outside a bush, okay? The defilement was occurring inside a bush. So the child was only watching, okay? So the wrong approach, but in this situation we are talking about goods, charging the lookout as if he personally broke into the shop and physically stole the goods without pleading or proving his participation. So students went ahead to charge the minor as if he was the one who participated in the defilement, even forgetting that a minor cannot engage in defilement. And the better approach is that depending on the evidence, he may be charged as a principal offender if he aided or abetted the commission of the offense. And under the Penal Code, persons who actually commit the offense do an act to enable or aid another person to commit it, aid or abet another, or cancel or procure another may be treated as principal offenders. So the possible charge in this situation is breaking into a building and committing a felony jointly with another contrary to the relevant provisions of the Penal Code. Now, which provision talks about breaking into a building and committing a felony? Which provision is that? Do you know the difference between breaking? Breaking So the legal definition of breaking is provided under section 303, and according to section 303 of the Penal Code, a person breaks a building if they break any external or interior part of the structure. Yes, housebreaking versus burglary. This is the difference that I wanted. So housebreaking is under section 303 and burglary is in 304. What is the difference between the two? So housebreaking happens during the day, while burglary happens during the night. So I believe with that we have clearly understood. Okay, we are seeing a decision here, Walter Kefa Gikonyo versus Republic, where the prosecutors usually couple a housebreaking burglary charge with a separate count of stealing from a dwelling house under section 279B. If items are stolen during the break-in, this felony carries a stiffer penalty of up to 14 years imprisonment. And non-residential buildings, if a person breaks into a building that is not used as a human dwelling, such as a shop, school, or warehouse, to commit a felony, they are charged under section 306, which carries a maximum penalty of 7 years. So let us have a look at 279. You see the distinction. So stealing from the person, stealing goods in transit, they said 279B. If the thing is stolen in a dwelling house and its value exceeds 100 shillings, or the offender at or immediately before or after the time of stealing uses or threatens to use violence to any person in the dwelling house, is liable to imprisonment for 14 years. Okay, so you have stolen a thing in a dwelling house and its value exceeds 100 shillings, and then you are told to also look at non-residential buildings under section 306. Section 306, breaking into a building and committing felony. Any person who breaks and enters into a schoolhouse, shop, warehouse, store, office, counting house, garage, pavilion, club, factory, or any building belonging to a public body, or any building or part of a building licensed for the sale of intoxicating liquor, or a building which is adjacent to a dwelling house and is accompanied with it, but it is not part of it, or any building used as a place of worship and commits a felony therein, or breaks out of the same having committed any felony therein, is guilty of a felony and is liable to imprisonment for 7 years. So hapa ni wakati examiner amekwambia a person has decided to break into a building licensed for the sale of liquor, intoxicating liquor, ameiba kwa church. So this is breaking into a building and committing a felony. We also have section 305 on entering dwelling house with intent to commit a felony. Any person who enters or is in a building, tent or vessel used as a human dwelling with intent to commit a felony therein is guilty of a felony and is liable to imprisonment for 5 years. And if the offense is committed in the night, the offender is liable to imprisonment for 7 years. So this is just an overview. Look at section 304 pia inaongelea housebreaking and burglary. Any person who breaks and enters into a building, tent or vessel used as a human dwelling with intent to commit a felony therein, or having entered into any building, tent or vessel used as a human dwelling with intent to commit a felony, or having committed a felony in any such building, is guilty of the felony termed housebreaking and is liable to imprisonment for 7 years. If the offense is committed in the night, it is termed burglary and the offender is liable to imprisonment for 10 years. So you can cite section 304 for 304(1) on housebreaking, 1A and B, and then 304(2) when you want to say burglary that is occurring at midnight or at the night. So it was very important for us to have a look at that part because anything is possible. Now, let us continue because we have exhausted that part. And now I'm going to the next part of it. I believe it was charging the main offender where the accused merely assisted. Now, the other mistake that you'll do is charging, aiding, and abetting where the facts show conspiracy. This is why I told you from the beginning, you need to understand, you need to know the different terms that are used in this kind of an activity, where we have an illustration where 3 people meet and agree to rob an M-Pesa shop the following day. They are arrested before buying weapons and going to the shop or confronting the complainant. So it will be a wrong charge to charge them for robbery with violence contrary to section 296(2) of the Penal Code. And why it is wrong? It is because no robbery has occurred, no property has been stolen, and there may also be insufficient acts to prove attempted robbery. So the better charge, depending on the evidence, is conspiracy to commit a felony contrary to the Penal Code. And the sections, sijui mbona niliacha ku refer to the provisions of the Penal Code because it is now proving that I must do a research. Next time I'll be very keen to make sure that every activity in a link with the provisions of the Penal Code. So I have to research this part, but Pia, from where you are sitting, if you are in a position also to do a quick research, I'll greatly appreciate. So under the Kenyan law, conspiracy to commit a felony is governed by section 393 of the Penal Code. It occurs when 2 or more persons agree to carry out a felony, making the agreement itself a distinct criminal offense punishable by up to 7 years imprisonment. So the relevant section is section 393 of the Penal Code. Section 393, conspiracy to commit a felony. Any person who conspires with another to commit any felony or to do any act in any part of the world which, if done in Kenya, will be a felony, and which is an offense under the laws in force in the place where it is proposed to be done, is guilty of a felony and is liable, if no other punishment is provided, to imprisonment for 7 years. Or if the greatest punishment to which a person convicted of the felony in question is liable is less than imprisonment for 7 years, then to that lesser punishment. And then immediately after committing a felony, conspiracy, we have conspiracy to commit a misdemeanor. Any person who conspires with another to commit a misdemeanor or to do any act in any part of the world which, if done in Kenya, will be a misdemeanor, and which is an offense under the laws in force in the place where it is proposed to be done, is guilty of a misdemeanor. And other conspiracies that can occur is where any person who conspires with another to effect any of the following, all the purposes following, that is to say, to prevent or defeat the execution or enforcement of any written law, to cause or injury, to cause any injury to the person or reputation of another person, or to depreciate the value of any property or any person, to prevent or obstruct the free and lawful disposition of any property by the owner, to injure any person in his trade or profession, to prevent or obstruct by means of any act or acts which, if done by an individual person, will constitute an offense on his part, the free and lawful exercise by any person of his trade, profession, or occupation, and to effect any unlawful purpose, or to effect any lawful purpose by any unlawful means, is guilty of a misdemeanor. So you can note on conspiracy to commit a felony, 393, 394, conspiracy to commit a misdemeanor, and other kinds of conspiracies arising from the Penal Code under section 395. So on the drafting point that I want you to capture is that conspiracy focuses on the agreement to commit a certain offense, and attempt focuses on acts done towards committing the offense. The two are not the same. An attempt is very different from a conspiracy. Another mistake that you'll do is to charge conspiracy where the evidence only shows preparation by one person. You've been told that an accused person is found alone with a fake number plate and gloves. There is no evidence of an agreement with anyone else. And the wrong charge is to say conspiracy to commit robbery. It is wrong because conspiracy requires an agreement between two or more persons, and a person cannot conspire alone. Okay? Because it is directly lifted from section 393 of the Penal Code, where any person who conspires with another to commit any felony, you cannot conspire on your own. So the better charge, depending on the fact, you can consider preparation to commit a felony. Okay? You can consider to charge on possession of suspected stolen property, possession of housebreaking implements, attempted offense if acts had gone beyond preparation, or no charge if the evidence is insufficient. So the drafting point is that do not charge conspiracy unless there is evidence of agreement between two or more persons. Then, the other mistake you'll do is to charge attempted offense where the facts show mere preparation. You'll be told by the examiner that a person buys a crowbar and is found near a shop at night, but there is no evidence that he tried to break the door, enter the premises, or confront anyone. So a possible wrong charge that you'll do is to charge this person of attempted breaking into a building and committing a felony. And this may be wrong because an attempt requires conduct that goes beyond mere preparation. The accused must have done an act sufficiently connected to the commission of the offense. So buying tools or being nearby may be suspicious, but may not necessarily amount to an attempt. And the better approach to this question is where you consider whether the facts support another offense, such as possession of a housebreaking implement, preparation to commit a felony, or other specific statutory offense. So you don't confuse preparation with an attempt to commit a certain offense. Now I'm happy because now we are going into sexual offenses. Charging the wrong sexual offense instead of an attempted sexual offense is also a mistake that you will do. An illustration is where an accused person has attacked a child and tries to undress her, but there is no evidence of penetration. So the wrong charge that you'll do is to do a defilement charge contrary to section 8 of the Sexual Offences Act, because it is wrong as defilement requires proof of penetration, and if penetration is not proved, the completed offense may fail. And the better charge is to, depending on the fact, attempted defilement contrary to section 9 of the Sexual Offences Act. So section 8 is the actual act, section 9 of the Sexual Offences Act is the attempted defilement, or possibly committing an indecent act with a child contrary to section 11 of the Sexual Offences Act. And this indecent act of a child with a child is usually appearing as an alternative count where attempted defilement will fail to meet the ingredients. And the drafting point that I want you to capture is that in sexual offenses, you need to distinguish carefully between penetration, attempted penetration, and indecent act. Now, another mistake you'll do is to charge murder where the facts show aiding after the fact. And a good illustration is where a person does not participate in a killing, but later hides the weapon and helps the suspect escape. And the wrong charge is murder, and this is because murder requires proof that the accused with malice aforethought caused the death of the deceased, either personally or through participation recognized by law. If the accused only assisted after the killing, he may not be guilty of murder unless there is evidence of prior agreement, common intention, aiding before or during the offense, or participation in the killing. This is a direct prediction that can arise in the case of the former governor Okoth Obado, and you are told that his accomplice merely assisted. They had a common intention, okay, otherwise than in the cause of killing, okay. You are in the cause of killing part. So there is evidence of prior agreement. We looked at phone calls. We looked at motives. We looked at the threats. We looked at the common intention. We looked at aiding even during the offense, and even possible participation in the killing. Therefore, we now charge you with murder. And it is very important because Okay. So, Section 396 of the Penal Code is on accessories after the fact. And definition of an accessory after the fact, I'll limit myself to that, is where a person who receives or assists another person who is, to his knowledge, guilty of an offense in order to help him escape punishment is said to become an accessory after the fact to the offense. Okay? And punishment of accessories after the fact to felonies, any person who becomes an accessory after the fact to a felony is guilty of a felony and is liable, if no other punishment is provided, to imprisonment for 3 years. So the better charge, depending on various facts in the factual matrix, is to consider offenses such as accessory after the fact, obstructing justice or police duties, harboring an offender, other relevant penal code offenses. And the drafting point, as usual, is I want you to take that assistance after the offense is different from aiding and abetting before or during the offense. And why is this part important? The part that you have categorically stated before you is that charging the wrong offense can lead to an acquittal because the ingredients are not proved. Amendment of the charge under Section 214 of the Criminal Procedure Code, it can lead to delay in trial, it can lead to prejudice to the accused, rejection of a plea of guilt if the facts do not support the charge, and conviction being quashed on appeal. At times, the examiner can decide to introduce rationale questions on why we need to be very careful in drafting various charges and charge sheets. So there is a drafting tip that I want you to master, and before settling on the charge, ask yourself, was this offense completed? If not, did the accused go beyond preparation? Was there an agreement with others? Did the accused help before, during, or after the offense? Did the accused personally take the property or only received it later? Do the particulars disclose every ingredient of the selected offense? So the safest charge is the one that accurately reflects the accused's provable role. And below, we have samples of a charge sheet for offenses that are commonly confused. We have completed offenses, attempts, conspiracy, aiding and abetting, handling, and accessory after the fact. For instance, if you take on stealing versus attempted stealing, count 1, the charge is stealing contrary to Section 268 as read with Section 275 of the Penal Code. And the particulars of the offense is that John Otieno on this day at Westlands stole a phone valued at this amount, the property of Mary Wanjiku. Now, where the accused tried to steal but was stopped before completion is now when you introduce attempted stealing, contrary to the famous provision that we said, Section 389, as read now with sections in regards to stealing. And look at how I'm particularizing my particulars. John Otieno on this day at Westlands Supermarket in Nairobi County attempted to steal assorted cosmetics valued at this amount, the property of Westlands Supermarket Limited, by concealing the said items in his jacket but was intercepted before leaving the supermarket. I've clearly indicated that the goods never left the supermarket. So the drafting point here is use attempted stealing where the evidence shows intention and acts towards theft, but the stealing was not completed. Another confusing element is stealing versus handling stolen goods. Where the accused actually stole the property, you charge him under stealing contrary to Section 268 as read with Section 275 of the Penal Code, and the particulars will be that Peter Mwangi on this day at this location stole this phone valued at this amount, the property of one Jane Akinyi. And now where the accused was found with or selling the property item later, but there is no clear evidence he stole it, you now invoke handling stolen goods contrary to Section 322 of the Penal Code. And now the particulars of the offense will read as follows, that Peter Mwangi on this day at this place, otherwise, you see how you cannot forget the key ingredients, otherwise than in the cause of stealing, dishonestly retained or assisted in the disposal of one phone valued at this amount, knowing or having reason to believe it to be stolen property. So that is handling stolen goods contrary to section 322 of the Penal Code. And this part is very important because remember we started with the theory part of it. Now when I'm introducing how to exactly draft a charge sheet before you, you're not now questioning the theoretical aspect of where I'm coming from. It is procedurally implicated, it is procedurally being fed into your brains. And the practical alternative count is stealing with alternative handling. So whenever you have handling of stolen goods, okay, so this is common where the prosecution is not certain whether the evidence proves the accused stole the property or only handle it afterwards. So good. So the proper practical alternative to stealing is usually handling stolen property pursuant to section 322 of the Penal Code, because the prosecution is not sure did he stole or did he handle it afterwards. So look at how I've introduced the same from what I'm trying to explain. Look at how I've decided to focus on the two aspects, section 322 and stealing directly as provided in section 268. And the drafting note is that do not charge handling if the prosecution case is that the accused was one of the actual thieves, and handling applies where the accused dealt with the property otherwise than in the cause of stealing. And we also have a distinction between stealing by servant. We have seen that when an employee steals employer's property, that will be stealing by servant, contrary to section 281 of the Penal Code. And Grace Njeri, on this day at ABC Traders Limited offices in Nairobi, being a servant of ABC Traders Limited, stole Kenya shillings to 50,000, the property of her employer ABC Traders Limited, which came into her possession by virtue of her employment. And where a non-employee steals from a company, you don't charge that person with stealing by servant, you charge him or her with stealing contrary to section 268 and as read with section 275 of the Penal Code. And where the accused only receives the employer's stolen property later, you charge them with handling stolen goods contrary to section 322 of the Penal Code, otherwise than in the cause of stealing. And we also have a distinction between obtaining by false pretense and attempting to obtain. Let us start with where money was actually obtained. So the charge will read obtaining money by false pretenses contrary to section 313 of the Penal Code, where the particulars are Samuel Kamau on this day at this place with intent to defraud obtained Kenya shillings 500,000 from Peter Omondi by falsely pretending that he was in a position to sell him parcel number this, a fact he knew to be false. So that is obtaining money by false pretenses contrary to section 313 of the Penal Code. Now, where the lie was made but no money was paid, this is where we said we invoke the famous section 389 of the Penal Code as read with section 313 of the Penal Code on offense on obtaining money by false pretense. And the factual patterns or the particulars of the offense will be that Samuel Kamau on this day at this place with intent to defraud attempted to obtain this amount from Peter Omondi by falsely pretending that he was in a position to sell him a parcel of land. This is a fact that he knew to be false. So if no money, goods or property was obtained, avoid charging the completed offense under section 313, and now you should consider an attempt. Now finally, or second last, we have robbery with violence versus attempted robbery with violence. And you said that where property was actually stolen with violence or threat, you insert the following charge. It is robbery with violence contrary to section 296(2) of the Penal Code. And the particulars will be as follows: that Brian Ouma, on the 3rd day of July, at this place, jointly with others not before court, while armed with knives, robbed Mary Otieno of one handbag, one Samsung mobile phone, all valued at Kenya shillings 62,000, and at or immediately before or immediately after the time of such robbery, threatened to use actual violence against the said Mary Otieno. Take note of how the particulars to robbery with violence charges are well detailed. Okay, I'll repeat for the sake of learning purposes that for robbery with violence, contrary to section 296(2) of the Penal Code, you are lifting the ingredients directly as stipulated in the Penal Code. So you list the person, which day, where was he. Now look at how ingredients start. You are jointly with others that are not before the court. While armed with knives, okay, you state the weapon, you robbed one Mary Otieno. You state the particulars of the items and the values, and at or immediately before or even immediately after the time of such robbery, you threatened to use actual violence against the said Mary Otieno. If you have raised your hand, I cannot be in a position to see, you can just unmute. Okay. But at times, the examiner can know you have known so much on robbery with violence, and now they can tell you there is violence or threat that has occurred, but nothing has been stolen. So if nothing has been stolen, you charge that individual with attempted robbery with violence contrary to section 297(2) of the Penal Code. And the particulars for such an offense will read as follows. Brian Auma on this day at this place jointly with others not before court while armed with knives attempted, okay? It is not robbed, they didn't rob. They attempted to rob Mary Otieno of her handbag and mobile money, and at or immediately before or immediately after the attempted robbery threatened to use actual violence against the said Mary Otieno. So drafting note that I want you to capture is that if no property was taken, robbery will fail. So consider attempted robbery with violence. Then another confusion is on conspiracy, attempt, vis-a-vis completed offenses. Where people agreed to commit a felony but were arrested before execution, what do you do? Now, you will charge this person with conspiracy to commit a felony contrary to section 393 of the Penal Code. And the particulars of the offense will be as follows. That one, James Mwangi, Peter Omondi, and David Kipto, because you cannot conspire on your own, on diverse dates between the 1st day of August and 5th day of August at Nairobi within Nairobi County, conspired together to commit a felony named robbery with violence by agreeing to rob Quick Cash M-Pesa shop situated at Umoja Estate in Nairobi County. That is identifier number 1. Identifier number 2 is where the examiner tells you there are acts that went beyond agreement and preparation. So in this situation, you charge attempted robbery with violence contrary to section 297(2) of the Penal Code. And the particulars of this offense will read as follows, that James Mwangi, Peter Omondi, and David Kipto on the 5th day of August 2026 at Umoja Estate in Nairobi County, jointly with others not before court, while armed with knives, attempted to rob Quick Cash M-Pesa shop of cash and mobile phones. Attempted, okay, and at or immediately before or immediately after the attempted robbery, threatened to use actual violence against Anne Wambui. Okay, so it is attempted robbery with violence contrary to section 297(2) of the Penal Code. If there was no aspects of violence, it is merely attempted robbery. And the drafting note is that conspiracy is about the agreement. Attempt is about acts done towards committing the offense. So do not charge attempt where the facts only show a plan or agreement. Instead, you go to section 313 on conspiracy as we saw. So not 313, 393 of the Penal Code, because we saw 393 a felony, 394 conspiracy to commit a misdemeanor, and 395 other types of conspiracies. I'm also brushing through as I teach you. So we have finished this part. Then how do you go about on aiding and abetting or joint offender liability? Under section 20 of the Penal Code, a person who aids, abets, enables, counsels or procures the commission of an offense may be treated as having taken part in committing it. So that is section 20 on parties and aiding. And how do you treat lookouts during thefts? So we said that for lookouts during a theft, it is stealing contrary to section 268 as read with section 275 and section 20 of the Penal Code. Take a look at how we are also introducing the aspect borrowed on aiding and abetting as provided under section 20 of the Penal Code, because you have aided, abetted, or enabled and even counseled or procured the commission of an offense, and it may be treated as having taken part in committing it. So if it may be taken as part of the offense, which offense are we talking about? Stealing. So it will be part of this stealing. Kevin Maina on this day, at this place, jointly with another not before court, stole assorted clothes valued at this amount, the property of his sleeve fashions, by keeping watch outside the complainant's shop while the other person removed the said clothes. How do you charge a robber who knowingly transports robbers to and from the scene? So this is robbery with violence contrary to section 296(2) as read with section 20 of the Penal Code, and the particulars of the offense is that Kevin Maina on this day while armed with pistols, jointly with the others not before court, while armed with pistols, robbed Sleeve Fashions Limited and cash all valued at 500,000, and at or immediately before or immediately after the time of such robbery threatened to use actual violence against Abdullahi Mohammed, the accused having aided the commission of the offense by knowingly transporting the said robbers to and from the scene. So you will not be an exception. You will be part of the people who committed the robbery with violence, even if you assisted person to section 20 of the Penal Code. So you do not always need a separate offense called aiding and abetting under the Penal Code. Often the accused is charged with the main offense, with section 20 showing the mode of participation. What do you do on accessory after the fact vis-a-vis aiding and abetting? Well, the accused person has helped before or during the offense. So take note of the difference. One, he is aiding but he is participating in the offense. The others, now where we are only being helped before vis-a-vis during the offense. And you will charge this person under robbery with violence contrary to section 296(2) as read in section 20 of the Penal Code, and the particulars will read as follows. Michael Onyango, on the 8th day, yes, you can unmute. Kuna mtu ameinua mkono. Okay. Michael Onyango, on this day at Dolholm, jointly with others not before court, while armed with knives, robbed Peter Karaoke of one motor vehicle, registration number this, Toyota Premio valued at this amount, and at or immediately before or immediately after the time of such robbery, threatened to use actual violence against the said Peter Karaoke, the accused having aided the robbery by providing information on the complainant's movements. So that is where the accused has helped before or even during the offense. Now, what happens where the accused has only helped the offender after the robbery? After the robbery, very important. And this is where you now invoke accessory after the fact to a felony contrary to section 397 as read with section 396 of the Penal Code. So take note of how the examiners were very tricky and very slippery. Did you help me before? Good, you are in it. Did you help me during it? Good, you are in that offense. But I'm invoking section 90 here. I'm reading it with section 90, aiding and abetting. But did you help me? Did you help the offender after he has murdered? Did you hide some items? So it is accessory after the fact to a felony. contrary to section 397 as read with section 396. Accessory after the fact. And the particulars will be that Michael Onyango, on the 9th day of October at 2026, or October 2026 at Donholm, knowing that James Kamau had committed the offense of robbery with violence. So there is an aspect of to his knowledge. Okay? To his knowledge. So you have an aspect of knowing there was an offense. Okay? Knowing that James Kamau had committed the offense of robbery with violence, assisted the said James Kamau to escape punishment by hiding him in his house and concealing the motor vehicle, this Toyota Premium. If the accused assisted before or during the offense, consider section 20 liability. If he assisted after the offense to help the offender escape punishment, consider accessory after the fact. And we have said there is an exception on common intention doctrine that was applicable in the Honorable Obado decision. Because they did not only conceal, they did not only prove this count accessory after the fact to a felony, but they even participated in it. Now, murder versus accessory after the fact to a murder, where the accused participated in causing death. This is a direct murder contrary to section 203 as read with section 204 of the Penal Code. Don't take these particulars as I've outlined here, because you will fail directly. You don't explain a charge, then you go to narrate the same way in the particulars, because we have the intention, the mens rea and actus reus that form the key ingredients to such offenses, and it is section 203 and 204 of the Penal Code. And 203 says that any person who of a malice aforethought causes death of another person by an unlawful act or omission is guilty of murder. So have a look at, there is malice aforethought, there is causing death of another person, there is an unlawful act. When you'll be drafting penal provisions in the LWD, one mistake that you'll ever do is to create an offense for lawfully permitted acts. So it must be an unlawful act, because if it is not unlawful, it is lawful, then it is manslaughter. In one or another, we can infer negligence. And if you look at section 206 on what constitutes malice aforethought, malice aforethought shall be deemed to be established by evidence proving any one or more of the following circumstances: an intention to cause the death of or to do grievous harm to any person, whether that person is the person killed or not. Knowledge that the act or omission causing death will probably cause the death of or grievous harm to some person, whether that person is the person actually killed or not, although such knowledge is accompanied by indifference whether death or grievous bodily harm is caused or not, or by a wish that it may not be caused. An intent to commit a felony, an intention by the act or omission to facilitate the flight or escape from custody of any person who has committed or attempted to commit a felony. That will constitute malice aforethought. Now, killing on provocation, hiyo itaingia manslaughter. Where the accused only helped the suspect after killing, this will be an accessory after the fact to murder, contrary to section 222 of the Penal Code. And this section provides as follows: accessory after the fact to murder. Any person who becomes an accessory after the fact to murder is guilty of a felony and is liable to imprisonment for life. Okay, it is after the fact to murder. So Daniel Mutua on this day at Kitengela, knowing that Peter Njoroge had murdered Joseph Kimani, assisted the said Peter Njoroge to escape punishment by hiding the murder weapon in transporting him from Kitengela to Namanga, he will fall under the 222 of the Penal Code. And the drafting note that I want you to take, I will not go into defilement because I don't want us to confuse issues, because I was intending to do defilement, attempted defilement, indecent act with a child, with how you should treat such kind of victims and such kind of witnesses in such offenses. So let us slot that for another day, and let us stress on the drafting note before you that you do not charge murder merely because the accused helped after the killing. Assistance after the offense is different from participation in the killing. And this is why I'm referring to the case of Okoth Obado. If they could have only tried to hid the body, or there is evidence showing that they disposed of the body after Obado maybe had killed in his own capacity, this will be a charge on accessory after the fact to murder, contrary to section 222 of the Penal Code. But since there was a common intention, they participated in it, automatically they are in murder, and you invoke section 20 of the Penal Code, aiding and abetting, and still you are in part of that offense. So why have I decided to deal with defilement issues separately? Because of one, we must find a way of how we will discuss Witness Protection Act, victim participation, the role of victims, okay, to what extent can victims participate, private prosecution, okay. You see, I want to use defilement as a way to give me an access to other topics inside the criminal litigation unit where students usually confuse. I was reading another day where a person cannot, okay, a high court cannot convict a person who had been acquitted. A high court cannot convert an acquittal to a conviction. But I saw an exception that the DPP amekuwa reserved a power to challenge an acquittal. Okay, to challenge an acquittal. I believe we did this part. We were discussing on criminal appeal vis-a-vis revision, vis-a-vis a petition for a new trial. And that discussion was very heated. It was a very heated debate. It was already recording in the YouTube channel. It was a very heated debate because students were confused. There was a set of facts laid before them. Alafu examiner akawaambia that the timeline for appeal has lapsed. I have discovered new evidence that could not have been within my reach at the time I was being convicted. Now, students wanachanganyikiwa between the following. Will you appeal? Okay, that is one. You are out of time, or if you appealed, your appeal was okay, katupiliwa mbali. Now, will you do revision, or will you do a petition for a new trial? So watu wakakoma the difference between revision and petition for new trial, and we narrowed down. Petition for a new trial is provided under Article 56 of the Constitution of Kenya, and for petition for a new trial is where you have discovered new evidence that out of due diligence you could not have come across it, and you verily believe that your conviction is unlawful, and your appeal, you had even appealed, or you are out of time to appeal. Okay, wacha kusema out of time. Okay, you have even appealed. Let me put it this way. You have even appealed and your appeal ikatupiliwa mbali. Now, if you do petition for a new trial, do you know now the application that you will do? Because the examiner in that situation wanted an application. So we drafted a certificate of urgency, tukaweka notice of motion, tukaweka petition. And the question carried 6 marks. Now a student challenged us na kusema, where will I get time to draft this petition for new trial, because my time is also limited. Because the examiner wanted an application, we drafted a certificate of urgency and a notice of motion, and in the supporting affidavit to this notice of motion, we told the examiner that we have annexed a petition for a new trial in these situations, because at the end of the day, our application was seeking bail pending the determination of the petition of our of the new trial, and we slotted that part for further discussion. Tukifika wakati tuna analyze the cause outline, tutafika that part. So those are the kinds of discussions that tuta engage in. And revision part. Revision, we said, ukiona issue to do with challenging a bail, bond, or illegally obtained evidence, you do revision. Na hii pia ni swali ilikuwa inaulizwa watu kwa JSC interviews, where a judgment has been procured illegally. What will you do? For criminal, you will do a criminal revision. For civil, you will do a review. Now, up to this part, sasa najua ndio uweze kufika the level yenye tumeingia, one or another, there is a deeper angle that we are going. Unajua wakati ndege inaenda kuanguka, inaenda kuchukua a deeper dive, pilots huwa wanajaribu kuengage autopilots, ikikataa kabisa wanawekanga hiyo ndege inatumia flaps. Flaps ndio zinakuanga the only saving instruments. I'm saying this because nilifanya aviation pale primary. So I'm an authority. So when the engine fails, both engines fail, you are only left at the mercy of the flaps in your wings. And these flaps are at the mercy of the wind. Okay? So now, mahali tuko, hatujaingia kwanza kwa flap. One engine imeanguka. And engine kuanguka, we are now surviving on one engine. Na this engine, wakati utaachana na hizi discussion, then that engine will itazima. And now what will happen? You will be surviving on the wind. And if CLE iangushe wind extraordinary, you will take a deep dive. Na hapo ndio pilot anasemanga watu wachukue face masks. Hawambiangi watu wafunge mishipi. Watu waweke face mask, because it is alleged that the oxygen mask yenye unaenda kuvaa iko na content yenye inakuwa slowly. It is released under extreme circumstances. The word is alleged. Okay? It is released under the extreme circumstances, where the airplane may take a deep dive, where the nose of the airplane may focus downwards. Hakuna a situation where inaitwa mayday. Hakuna situation where any flap can save that plane. Any kind of wind haiwezi okoa where the nozzle may face downwards. So wakati sasa utasikia tumebakisha wiki moja na haukuwa na engine moja imebaki, na hii engine moja ni these discussions, automatically just know you will be wearing the mask, the oxygen mask that is going to kill you direct ukiangalia. And this selection, wewe ndio umechagua that this year I'm doing criminal litigation. Remember CLE imekwambia if you are not ready, you can get off the plane in one of the unit. If you are courageous, at 8:15 join us to pick a 2023 papers. And deliberately we are starting with LWD, as we said, in one session, and in the next session we will go to the substantive conveyancing, ndio tuendelee where we had left from. So unless there is other suggestion, because time ilikuwa inaisha at 8, what are your feedbacks. How are you viewing these sessions? You can unmute and say a word, because from my end mimi nimemaliza.
Victor? Vicky,
Yes?
when is the next session? What time?
The next session is starting at 8:15 p.m. and itaisha at 9 p.m. so that we give way to the next paper, so that at least in one night tunapiga 2 papers and a webinar hii masaa.
Okay, sawa. I think now I would maybe try to bring this up the next criminal time tutakuwa tuna revise criminal. You may notice again a lot of peer questions come from jurisdiction. In as much as tunaweza kuwa tunajua like juju, but we have to go through the criminal procedure code. I don't know if we did that before, but I would request we go through it again, because I saw a question ya 2026 ilikuwa inauliza about kama court of appeal inaweza ongeza sentence from maybe high court ilikuwa imesentence someone 5 years and then court of appeal ikuje extend the sentences. What is the legality of it and what is the condition of that? So yeah, I would request pia maybe tuongee about that.
That is well. Thank you, Abigail. That is well captured. In the next session, in fact, I will start with that on jurisdiction. But here, maybe to answer on your feet, I saw that, and the answer maybe to attempt is that the court has the power to enhance or reduce a sentence. And this was seen where in a case that I read, mtu alikuwa amefungwa for a certain number of years, alafu ikapatikana that the law provision that the magistrate had add in convicting this person on that provision, because it had a minimum number of years on that provision, and now akafungwa 10 years as compared to the 3 years that the magistrate had implied to in the act. So one area ni kama where the offense where there is an error apparent on the section of the law where you have been convicted. Madam Abigail, maybe you can clarify on that, so that what was Yacho hanging, what was the answer?
So the question the question was about some people are convicted of an offense against ile act ya narcotic drugs, so wakapelekwa mbele ya magistrate, wakapewa a fine na imprisonment ya 7 years. So aggrieved by that conviction, lodge the first appeal to the High Court. So the Court of Appeal, the High Court dismiss the appeal against the conviction, set aside the sentence of 7 years. And then the judge then enhanced that sentence to a term of life imprisonment na add fine ya 1 million. So in setting aside the term of 7 years, setting you akiongeza, let me just setting aside kumbuka the previous conviction ilikuwa 7 years, so wamekuja High Court wamepewa life imprisonment. So nimeweka hii question hapa kwa the question sasa ilikuwa inasema, citing the relevant legal provision and case law, analyze the jurisdiction of the Court of Appeal in appeals of the nature depicted in the facts. So I think sikuwa nimemaliza the facts. So after kumbuka sasa tuko High Court, wamepewa hiyo life imprisonment. Hawa appellants then wakasema the appellants were further aggrieved by the judgment, wakaenda kwa Court of Appeal. So now you've been told you're working for that some advocates and you've been handed over that brief. So unaambiwa analyze the jurisdiction of Court of Appeal in appeals of the nature depicted in the set of facts, alafu draft pleadings. So drafting pleadings to highlight at least 2 possible grounds of appeal. So nikiangalia hii question, wanasema that it is a word for word a case inaitwa Sami Omboke and another versus Republic. So hii kesi walikuwa wana deal na jurisdiction of the Court of Appeal wakisema that remember, of course, the aggrieved parties wanataka to set aside your life imprisonment. That is the facts behind our clients. So inasema a second appeal. This is a second appeal because the matter has already gone from a subordinate court to a high court. Therefore, Court of Appeal's jurisdiction is governed principally by Section 361 of the Criminal Procedure Code. Under Section 361A, 1A of the CPC, a second appeal lies to the Court of Appeal only on matters of law. We know that, definitely. The courts cannot ordinarily reconsider findings of facts made by trial court and affirmed by the High Court. However, a finding of the fact may be inferred with where, for example, 2 courts considered matters they ought not to have considered, or failed to consider matters they ought to have considered, or they were plainly wrong on the evidence. So wanasema that wanacite pia some case laws higher. The next thing wanasema, kwa hiyo tu Section 361B, CPC generally bars an appeal against sentence on a second appeal because severity of sentence is treated as a matter of fact. However, an exception exists where the High Court had enhanced the sentence, or where the subordinate court had no power to impose the sentence. Therefore, in our present case, the Court of Appeal has jurisdiction because the High Court enhanced the sentence from 7 years to life imprisonment and imposed a fine of 1 million. More importantly, this is so important, by the way. More importantly, the appellant can raise questions of law concerning the legality and jurisdiction of the High Court in enhancing the sentence. In that case, in Sami Omboke versus Republic, which has virtually identical facts, the court held that though High Court has power under Section 3543 of CPC to alter or enhance a sentence, it has no jurisdiction to enhance the sentence without a prosecution's cross-appeal. So isn't a condition. Prosecution cross-appeal, notice of enhancement, now warning to the appellant. So the court ought to have had kunafaa kulikuwa during sasa before the High Court, kunafaa kuwa kulikuwa na application ama cross appeal ya prosecution wakisema that wakiwaambia that wanafaa ku enhance sentencing. Haifai kukua like on suo moto. They cannot work on suo moto, that is the High Court. Number 2, kunafaa kukuwa na hiyo notice of enhancement to the appellant, and then kunafaa kukuwa na warning to the appellant. So the court also held that the charge was fundamentally defective in just the question, but mainly my emphasis ilikuwa just kujua jurisdiction of each court in every step of the criminal procedure. So this is just learning the procedure and the sentencing bit. Kuna bado the bail unafaa kujua kwa each courts na hizo vitu zingine. So I think it is important kupitia hizo ma sections na kujua the jurisdiction. Yeah.
Thank you. Maybe for key takeaway for people wajaelewa what Madam Abigail was stating, but ako very clear in her argument, is that I've captured, I hope the screen is visible, I've captured that part yenye ina relate to the decision. So the principle enunciated by the Court of Appeal is that before a sentence is enhanced, The practice is to warn the appellant beforehand of the possibility of the sentence being enhanced during appeal. This was succinctly put by the court in Sami Oboke and another versus Republic 2019, Kenya Law Report Kisumu, that a ground urged in this appeal relates to enhancement of sentence without warning, notice, or a cross appeal. So there can be either a warning, a notice, or a cross appeal. This court in Samuel Mbugua Kihanga versus Republic 2011 explained that although the practice of warning the appellant before enhancing the sentence was not a requirement of law, it was a matter of practice and that had gained notoriety and served to put the appellant on notice of the consequences that would befall him depending on the outcome of the appeal. And the court continued that in the instant appeal, there was no cross appeal by the prosecution for enhancement of sentence before the High Court, nor was there a warning to the appellants by the court that the sentence meted upon them could be enhanced. There was no notice of enhancement. Guided by the judicial pronouncement of this court above, we find that the learned judge erred in enhancing the sentence meted out on the appellants in the absence of a cross appeal and a notice and or warning. The judge had no jurisdiction to enhance the sentence. Let me bring the point home kabisa. Sami Oboke versus the Republic. So Madam Abigail, we greatly appreciate such kind of observations and we are very amenable if you can be pointing out other aspects of this kind of tricky positions. So I will not ignore the jurisdiction element of it, and I've captured the bail and bond applications in various jurisdictions, and then we will meet in the next webinar where we will be discussing such kind of activities. So I want us in the webinar series, anyone akona such kind of observations like Madam Abigail, and feel free to speak it out and share with us so that we greatly appreciate na kila mtu anaelewa how to deal with such. So nana attendance haikuangi kubwa for high impact sessions. So thank you, unless there is another person. Any other observation from any member? Okay, so with the silence, let us meet at 8:15 to discuss on CLE 2023 papers. So members, so we are at liberty to leave the session. So, sir, you are at liberty. Niulize on the kind of engagement on past paper questions. How do you find it? Are you gaining something? Madam Abigail na Brian, are they serving their purpose from your observation? Oliver, umechelewa, umeingia wakati session imeisha, but kuna session inaanza 8:15 to
Yes, hiyo ndio nangojea. I'm waiting for that session. Acha ningoje.
okay, sawa. Okay.
Vicky, bado kuna ya 4 am.
Hiyo ijaitoka. It was a pattern that we had to cultivate mbio ndio tulijua tuna time. So ijaiisha.
Okay.
Okay, so basi nianze this recording nikuwe nikiupload as I prepare for the next session, ndio nikuwe nimeprepare in advance. Sasa thank you Abigail na Brian.